Let me start with something that might make you uncomfortable. The fastest way to end a traffic stop is not to be polite. It's not to be charming. It's not to just explain what happened. And it's definitely not to answer every question in the hope that cooperation buys you mercy. The fastest way to end a traffic stop is to remove yourself from the conversation. I know that sounds counterintuitive. Every instinct you have tells you that when a police officer walks up to your window with flashing lights behind you and adrenaline pumping through your chest, the smart move is to smooth things over, to be agreeable, to show you're one of the good ones. That instinct is human. It's also the reason I've watched hundreds of body camera videos where an ordinary traffic stop turns into a search, and a search turns into handcuffs. I've sat in courtrooms and listened to officers testify. I've cross-examined them in suppression hearings. I've watched judges decide whether evidence stays in or gets thrown out. And over again, what decides the outcome isn't what the officer saw. It's what the driver said. So today I'm going to give you 4 phrases that, when delivered calmly and correctly, can end most traffic stops in about 90 seconds. Not because they intimidate anyone, not because they're magic words, but because they shift the legal ground under the officer's feet. And the phrase that anchors all of this, the one you need to burn into your nervous system until it's automatic, is this: I don't answer questions. Not shouted, not sarcastic, not confrontational, just steady. I don't answer questions. That sentence is the spine of everything we're about to talk about. Picture this. It's 9:42 p.m. You're driving home from work. Maybe you're tired. Maybe you're coming back from dinner. The red and blue lights hit your rearview mirror, and your heart rate spikes before you even process what happened. Your hands feel slightly numb on the steering wheel. You pull over, and already your brain is racing through possibilities. Was I speeding? Did I miss a signal? Is my registration up to date? The officer approaches. First question, almost universal. Do you know why I pulled you over? That question sounds casual. It sounds conversational. It's not. It's investigative. Now, this is the part most people misunderstand. That question is not about information. The officer already believes they know why they stopped you. It's about admission. If you say, "Yeah, I was probably going a little fast," you just handed them probable cause wrapped in a confession. If you say, "I didn't realize I rolled that stop sign," you just saved them the trouble of proving you did. I've watched body cam footage where a driver talks for 30 seconds, just trying to be honest, and that 30 seconds becomes the strongest evidence against them. What happens if instead you calmly hand over your license and registration, and when asked why you were stopped, you say, "I don't answer questions"? There's usually a pause, a subtle shift, because now the officer has to decide whether they're going to escalate or just move forward with the reason they already had. Here's where this gets complicated. You are required to provide identification in most states when lawfully stopped while driving. You are not required to engage in conversation beyond that. The Fifth Amendment protects you from being compelled to incriminate yourself. That doesn't just apply in a police station interrogation room. It applies on the side of the highway with traffic flying past at 70 miles an hour. But officers are trained in conversation. They're trained to build rapport. They're trained to look for inconsistencies, to pick up on nervousness, to use silence strategically. I've heard officers testify, "I asked where he was coming from and where he was headed, and his answers didn't make sense." That "didn't make sense" becomes the justification for extending the stop. And the longer the stop lasts, the more likely it turns into something else. This is the trap. Traffic stops are supposed to be temporary and limited to the purpose of the stop. The Supreme Court has been clear on that. The officer can address the traffic violation and handle related safety concerns. They can check your license, registration, and run warrants. What they cannot do, at least in theory, is prolong the stop beyond the time reasonably required to complete that mission just to fish for evidence of other crimes. But here's the gray area. What counts as prolonging? What counts as reasonable? That's where ambiguity lives. And ambiguity is where officers operate best. So when the officer asks, "Where are you coming from tonight?" it sounds harmless. If you say, "Just coming from a friend's house," they may follow up. "Which friend? How long were you there? Did you have anything to drink?" You see how quickly that snowballs. Instead, you return to the anchor. "I don't answer questions." It feels awkward the first time you imagine saying it. You worry it sounds suspicious. You worry it will make them mad? Let me be honest with you. It might. There is a hard truth here. Asserting your rights does not guarantee you a pleasant interaction. Some officers interpret it as hostility. Some will stiffen. Some will switch tone. But there is a difference between discomfort and danger, and there is a difference between temporary inconvenience and permanent legal damage. I would rather defend a client who was quiet and mildly inconvenient than one who was chatty and cooperative and talked themselves into charges. Now imagine the stop continues. The officer takes your documents, goes back to their cruiser, runs your information. They come back. Maybe they issue a warning. Maybe they're writing a citation. And then comes the pivot. Do you mind if I take a quick look in your vehicle? This is the moment where most people collapse, because the request sounds small. Just a quick look. It's framed as voluntary. It's framed as no big deal. But consent is one of the most powerful tools in law enforcement. If you consent to a search, you waive a massive chunk of your Fourth Amendment protection. You eliminate the need for probable cause. You remove the requirement for a warrant. You gift them legal authority they did not previously have. So the second phrase you need in your arsenal is this: I do not consent to any searches. Again, calm, clear, no attitude. I have replayed footage in court where a driver said, I guess that's fine, or sure, I don't have anything to hide, and inside that car was something that changed their life. And I've had judges look at that footage and say, well, they consented. You might think, but if I say no, won't that make me look guilty? Here's where we separate fear from law. Refusing consent cannot legally be used as evidence of guilt. Courts have been explicit about that. You are allowed to insist on your constitutional rights without that being turned against you. Does that mean an officer won't be irritated? No, but irritation is not probable cause. There's a case I handled a few years ago. Young man, clean record, pulled over for a minor lane violation. Officer asks where he's headed. He says he's coming from a party. That was mistake number 1. Officer asks if he had anything to drink. He says, just 1 beer. That was mistake number 2. Now the officer smells the odor of an alcoholic beverage. Field sobriety tests follow. Then a vehicle search. A small amount of marijuana is found in a backpack in the trunk, belonging to a friend who had borrowed the car earlier that week. What started as a lane violation turned into a DUI investigation and a drug possession charge because of a handful of conversational answers. Contrast that with another client. Similar stop, similar time of night. Officer asks the same questions. My client hands over documents, says, I don't answer questions. Officer asks for consent to search. My client says, I do not consent to any searches. Officer runs the license, writes a warning, and the stop ends in under 10 minutes. No search, no fishing expedition, nothing to litigate later. Now this is the part most people misunderstand. These phrases are not about antagonizing police. They are about narrowing the scope of the interaction. When you remove voluntary conversation and voluntary consent, the officer is left with the original reason for the stop: speeding, broken taillight, expired tag. That's it. And if they want to go further, they need something more than curiosity. Here's where it turns. Sometimes the officer doesn't ask for consent. Sometimes they escalate verbally instead. Why are you being difficult? If you've got nothing to hide, why not let me look? It'll only take a minute. These are psychological levers. They're designed to make you feel unreasonable, to make you feel like the only thing standing between you and a smooth exit is your own stubbornness. This is where your third phrase comes in. Am I being detained, or am I free to go? That question is not rhetorical, it's legal. Because once the purpose of the traffic stop is completed, once the citation is written or the warning is issued, any further detention requires additional legal justification. If the officer says you're free to go, you leave. If they say you're being detained, then we're in a different category of interaction, and they must be able to articulate why. I have seen officers stumble at this point. I've seen them say, well, just hang tight for a minute, without clearly articulating reasonable suspicion. That ambiguity matters later in court. But here's the nuance. You don't ask that question 30 seconds into the stop. You don't interrupt them mid-sentence. You wait until the traffic mission appears complete. Timing matters. Tone matters. You're not trying to win a debate. You're trying to mark the boundary. Let's talk about adrenaline for a moment. When those lights come on, your body goes into fight or flight mode. Your pupils dilate. Your heart rate increases. Your cognitive processing narrows. That's biology. And under stress, people talk more, not less. They over-explain, they ramble, they try to fill silence because silence feels dangerous. Officers know this. Silence makes people uncomfortable. They'll stand there and look at you. They'll let the quiet stretch. And many drivers break it themselves. So your fourth phrase, the one that feels the hardest, is sometimes nothing at all. It's silence after you've said, I don't answer questions. It's not adding qualifiers, not saying, unless I have to, not nervously laughing, just letting the statement stand. This is where body language becomes critical. Keep your hands visible, movements slow and deliberate, voice steady, no eye rolling, no smirking, no dramatic sighs. Calm compliance with lawful commands. Documents provided. Windows lowered as required. Interior light on at night. You are not resisting. You are not obstructing. You are simply declining to volunteer information. Now let me address the exception everyone worries about. What if the officer already has probable cause? What if they claim they smell marijuana? What if a drug dog is called? If they have lawful probable cause, your refusal to consent won't stop a search, but it preserves your ability to challenge that search later. Because if the only justification was consent and you never gave it, the evidence may be suppressed. If they claim probable cause independent of consent, we can scrutinize that claim. We can examine bodycam footage. We can cross-examine their testimony. But if you consented, that door is closed. I once cross-examined an officer who testified that my client appeared extremely nervous, that his hands were shaking, that he avoided eye contact. On bodycam, my client looked like any other human being pulled over on a dark highway. Nervousness alone is not reasonable suspicion, but nervous answers, inconsistent statements, admissions about travel plans, that's what gave the officer more to work with. This is where I tell you something uncomfortable again. Even if you do everything right, even if you say the phrases perfectly, the stop may not end in 90 seconds. It may take longer. The officer may decide to run a K-9 unit if they believe they can articulate reasonable suspicion. You may sit there for 15 minutes instead of 5. That is the hard truth. Asserting your rights can sometimes cost you time. It can create friction. It can feel tense. But what it does not do is create evidence. And evidence is what follows you into court. The legal system runs on words captured on camera. Judges watch footage frame by frame. Prosecutors replay your statements in slow motion. Jurors hear your tone. I guess I was speeding a little. Yeah, I had one drink. Sure, go ahead and look. Those sentences echo. I don't answer questions. I do not consent to any searches. Am I being detained or am I free to go? Those sentences close doors. Now imagine the stop again, but this time you're rehearsed. Lights flash. You pull over safely. Engine off. Hands on wheel. Officer approaches. You greet them politely. You provide license and registration. They ask where you're coming from. I don't answer questions. They ask if there's anything illegal in the vehicle. I don't answer questions. They ask for consent to search. I do not consent to any searches. They finish writing the warning. There's a pause. You ask calmly, am I being detained or am I free to go? If you're free to go, you leave. If you're detained, you remain silent and let the legal process unfold without helping build the case against you. Notice what's missing from that scenario. No arguments about constitutional theory, no lectures, no threats about lawsuits, just controlled, measured language. This is not about being anti-police. It's about understanding that an officer's job is to investigate. Your job is to protect yourself. Let me tell you something else I've learned from watching countless hours of footage. Officers often decide within the first 30 seconds whether a stop will remain simple or become exploratory. They're reading you, your tone, your movements, your answers. If you start talking about your evening, if you volunteer information, if you try to joke your way through it, you're giving them threads to pull. When you calmly decline to engage beyond what is legally required, many officers simply move on. Not all, but many. There's a kind of quiet professionalism in that interaction. They do their job. You protect your rights. The encounter ends. Now here's where this gets even more subtle. Some people think invoking rights requires magic words like, I invoke my Fifth Amendment privilege against self-incrimination. That's courtroom language. On the roadside, plain English works. I don't answer questions is clear. It's unambiguous. It doesn't invite debate. And clarity matters. Because ambiguity is where officers operate. If you say, I'd rather not, that can be interpreted as hesitance, not refusal. If you say, I don't think so, that's uncertain. If you say, I guess not, that's consent's cousin. Be clear, but also be calm. Anger is combustible. Sarcasm is gasoline. Calm repetition is concrete. And if the officer ignores you, if they keep asking, you repeat the phrase. You don't escalate. You don't change it. You don't start explaining why you're not answering questions. You just repeat it. There's a psychological effect to repetition. It signals boundary without hostility. It removes the conversational hooks. I've seen stops where the driver talks for 6 straight minutes before the officer ever asks for consent to search. By then, the officer has built a narrative. Inconsistent travel plans, visible nervousness, vague answers. That narrative becomes the basis for reasonable suspicion. That's how a broken taillight becomes a full vehicle search. This is how the system actually works in real life, not in theory, not in civics class, in courtrooms with fluorescent lights and worn wooden benches. Officers testify about what you said, prosecutors argue about what you meant. Judges rule on whether your words justified the next step, and the difference between a warning and a charge is often conversational. So when I tell you that 4 phrases can end a traffic stop in 90 seconds, I'm not promising magic. I'm telling you that removing yourself from voluntary conversation collapses the investigative runway. I don't answer questions. I do not consent to any searches. Am I being detained, or am I free to go? And sometimes, silence. Rehearse them, not because you plan to use them tomorrow, but because under stress, you don't rise to the occasion. You fall to your level of preparation. Practice saying them in a mirror. Practice saying them calmly. Practice keeping your voice steady, because when those lights come on behind you, your heart will pound, your mouth will go dry, your brain will scramble for approval and safety, and in that moment, the simplest sentence in the world may be the one that protects you. I don't answer questions. Say it until it feels natural. Say it until it no longer feels confrontational. Say it until it becomes automatic, because the system runs on words, and the fewer you give it, the faster you get home.